This hit the nail right in the head because, as I positioned in the video, the problem with the court in general is the fact that it has no constitutional structure. It has no constitutional ethics. Why? Because as government has failed to actually clarify Article 3, which is literally incomplete. Incomplete. It is disastrous how incomplete it is, and it's on purpose because through ambiguity you're capable of producing a court system that benefits your certain agenda, and that's what we have inherited, a type of Supreme Court that chooses a side. And ultimately, when you look through Federalist 78 through 83, the only doctrine the justices should be aligned to is the Constitution and the laws. But primarily when we're talking about the Supreme Court, is the constitutional social contract, not necessarily the laws, if that law is against the constitutional supremacy. We see this in evidence such as the states that have decided that the Second Amendment protects all arms and there's no room for regulations, which is inherently false because that would be to pretend like you're not reading the Equal Protection Clause, which allows for the regulations of certain liberties if that becomes an increased threat against the right to life of other equal persons. How are they capable of doing this? They are capable of doing this because the courts only have their structure of legitimacy through the Federalist Papers, particularly Federalist 78 through 83. But that is not the Constitution. That is an extra guidebook of how the Constitution should be driven. However, there are things within the Federalist Papers that are misaligned with the Constitution. So as any contract, the only thing that matters is that contract. However, the courts have adapted two distinct ways of creating their judicial decisions, and this is between originalism and constitutionalism. Originalism is interpreting the contract based on the intentions of the founding fathers and the policy writers. So it's asking the questions, not what's in here in the text, but what were they thinking when they wrote it so that we understand whether it can be regulated or not, which makes no sense under the rule of law. I haven't gone to law school, although I have a master's in international law, but I study immensely, so I know that a contract is a contract. It's binding. If you sign it, that's it. That's it. Your intentions don't matter. Yet, they found a way to keep this binding. Why? Under the name of tradition, American tradition. Yet, American tradition has always positioned that under the preamble of the United States Constitution, we are striving to create a more perfect union. How can we have a more perfect union when we are bound by the opinions of those who were born within eras in which there was immense violence, inequality, and political and legal discrimination? Rather, we should maintain ourselves within the boundaries of the constitutional supremacy and the social contract. Article 5 exists because we are supposed to evolve it. We have a living constitution. But originalism has allowed, historically speaking, for conservatives to have much more political pull under the guise of American tradition. Originalism is why courts are capable of interpreting that 2A is unconditional. It allows for them to ignore the fact that there's literally a part in the Constitution that allows for regulations. In reading just the Second Amendment without the context of the entire Constitution, it allows for them to use that ambiguity to leverage judicial power for a certain side. Historically speaking, originalism has been harmful to especially disenfranchised people. Examples of originalism is the Three-Fifths Compromise. Because if all men are created equal, then why were black men not equal? Because originalism, the original makers didn't want to make them as equals. Then why put all men are created equal? Because they did not consider black men as men. So instead of the social contract of what they said was true, which is all men are created equal, originalism positions weight on the intentions. Now, how can this go wrong? Because the only reality where the Supreme Court is capable of ignoring constitutional supremacy is one where it uses originalism against constitutionalism, which is forbidden per the Supremacy Clause and backed up by Federalist 78 through 83. But that's the Federalist Papers, not the United States Constitution. You may say that, right? In that case, you may be right. Except with the very things that coincide with what's within the Constitution. But think about that. If we cannot put weight only on the essays within the Federalist Papers because of Article 6 Supremacy Clause, which assures that the Constitution is the law of the land, not the Federalist Papers. Wouldn't that mean that if the courts only derive their structures and ethics and powers from mostly Federalist 78 through 83, then wouldn't that put into question whether their powers are even real? Or at the very much, it positions a concern that there is too much ambiguity within the judicial system that makes it outside the control of constitutional supremacy. Because technically speaking, we don't even have anything as to how to remove a justice within our Constitution. That is on purpose. It is willful. Again, through originalism, the last amendment was in the 90s. But originalism keeps us in the past. It keeps us paralyzed. Originalism is believing that America was founded as a Christian nationalist utopia. These type of people will often cite the Declaration of Independence, 1776, which has a lot of Christian things. However, Article 6 Supremacy Clause 1789 says that the Constitution is the law of the land in the United States. That cancels out the Declaration of Independence, because when it comes to the Bill of Rights positions that all of the amendments are as valid as the original Constitution. This means that the separation of church and state is valid and supreme to what's in the Declaration of Independence. An example of a place where originalism and constitutionalism can coincide is the end, where it says we mutually pledge to each other our lives, our fortunes, and our sacred honor. So we pledge to each other to defend each other, security, right? Our fortunes through taxes, and our sacred honor, which is our pride. Why am I telling you this? Because ultimately, the maintainment of the political status quo by plentiful of political ideologies within Washington, D.C., has allowed for this to happen. A lack of being proactive, a lack of protecting. Republicans have been telling us that they wanted to remove the administrative states, but instead of positioning remedies to that, and in order to attempt to safeguard it, particularly the greatest argument is that under Article 1, lawmaking is only for Congress, not for the executive, which is true. But rather than solving that, we waited and waited, as we have reproductive rights, with LGBT rights, police brutality. We wait and wait and wait. And this produced willful compliance, a bipartisan maintainment of the political status quo at the cost of American democracy, American elections, American security, American domestic interests. This political status quo of not challenging judicial and political originalist decision-making is why we have Citizens United, why we have corporate personhood. The case of 1886 Santa Clara County versus Southern Pacific Railroad is the parasitic root of corporate personhood that makes Citizens United possible. Here, an expert turned attorney, former congressman, who was in the room as the 14th Amendment was being written, told the court, "Trust me, I was in the room. We chose person and the Equal Protection Clause versus citizens because we wanted corporations to be persons." And that's originalism. Originalism is basing it based on those who wrote it and not the text. And any other contract, that would be ridiculous. And I think the silver lining here is that whatever happens, we will rise. However, whatever political shock happens will result judicial reform required to become a greater nation.